So I want to thank Caroline again for that wonderful introduction, and also to thank her for inviting me to what promises to be quite a wonderful conference to be the keynote speaker. Before I start, I also want to acknowledge, especially in the context of what I'm going to be talking about in this presentation, those who have been the subject of law's violence, or those who have been subject to law's violence, and remind us that these are people with dreams, with aspirations, with flaws, with their own faults, and we should try within the context of legal history to always make them present in our work, to acknowledge their existence and their sort of their pitfalls, their trials and triumphs. So very a brief outline. Caroline has talked about my book, and most of what I will be talking about in this presentation comes from the book. So the book examines quite broadly the relationship between legal history and decolonization. Personally, for me, it's impossible to talk about the concept of decolonization within the law without examining legal history. So I will be focusing on some of the research that I have done from the book, but with a particular focus on the sections that have to do specifically with the way in which law relates to the construction or deconstruction of time. I will sort of towards the end arrive at some conclusions about that relationship, and then I'll read a very short extract from the book. So this essentially is the book itself, so the book cover and the chapters. So the research that I will be talking about in this presentation focuses mainly on the 5th chapter of the book. So this is defining the law's subject, law, time, and colonialism, slow violence. But before I go into that particular focus, I want to contextualize the book, the main arguments of the book. So my discussions of chapter 5 will sort of have some resonance with within the context of the book, so it doesn't sound, very abstract, which there's a possibility that happens. So my scholarship since my PhD, essentially I've been working on this book, or thoughts around producing this book, or thoughts that have led to this book since I finished my PhD. But I've focused since including my PhD, on the effects of incomplete decolonization of African polities, for example, third world approaches to international law, the continued education dependency, and humanitarian intervention. But with the increased focus, I would say, on decolonization in UK higher education, I was increasingly drawn into this conversation, but also increasingly frustrated at the fact that most of the conversation around decolonization in UK higher education didn't link itself to this sort of the history of colonization and sort of decolonization. And for me, I feel that one of the reasons that people struggle to engage with decolonization properly is because they have an incomplete and limited understanding of what colonization and colonialism entail. So what I'm trying to do in this book to focus on is on unpacking the latter. So what is colonization, colonialism? What do they actually entail? What do they produce? Rather than advocating for decolonization. So the book is not in any way a one, how do you decolonize, and two, it isn't you must decolonize. My hope is that if there's an adequate understanding of enduring colonial logics and praxis, this will in itself be an adequate invitation to decolonize, however we want to define that nebulous concept. And I'll come back to why I think it's nebulous in a second. So just to very briefly try and sort of summarize the main arguments or the context of the book and where my discussion of legal history fits in, specific discussion of legal history fits in here. My first concern in the book is the why of decolonization. And here I try and explain why in 2022 we're still seeking to figure out how to respond to the modalities of life that colonization and colonialism introduced, and which have been made universal and normative. These universalizations of colonial epistemologies, they show up in various ways in undergirding the key concepts of legal knowledge. The second concern of the book is the what of decolonization. In other words, if colonialism, beyond the temporal spatial limits of colonization, as a way of thinking, being, and doing, has become so naturalized, what then can be described as decolonization? This is especially important if we are to think of decolonization beyond the questions of diversity, inclusion, and representation, as we often do. And history and the present tells us that we must think beyond EDI when we're considering decolonization and colonization and colonialism. So by looking at how the logics of colonialism were responded to and are still being responded to, we then should understand that decolonization is many things. It is context dependent. In other words, we find the meanings of decolonization in how the tools that colonized and indigenous and racialized people have in the places where they are used to address the effects of colonization and colonialism where they are. So the core of the book, the main thing I try and focus on is the law. So how the law is, or I try and trace exactly how the law and its concepts have been involved in the processes of racialized enslavement and dispossessive colonization. The aim is to evaluate the possible effects that evolvement may have had on the current nature of the law. If we accept that the law constructs realities, then we must explore how these processes, praxis, and logics have had an effect, not just on the realities that we exist in currently, but also on the ontology of the law itself. I go to, I break down that effect into 3 chapters and examine them in a separate, examine them separately but in a cumulative manner. So I examine the effect on subjectivity under the law, the effect on meanings of land, space, and place, as well as the effect of this process on meanings of time and temporality. And it's on that sort of examination of time and temporality that I will focus the rest of this presentation. My contention is that the way in which the law constructs the realities of body and space-time means that we are mostly unable to break from those realities using the very sort of only figure of the law itself, and create new ones that do not reproduce the racial violence, extreme inequality, and endangerment of the planet that the law has helped to bring to fruition. So as I said, in the 5th chapter, which is called Law, Time, and Colonialism's Slow Violence, I focus very much on legal history and how, so not just on legal history as sort of an account of this is what has happened, but how this has produced a particular ontology of the law and law's relations to time, and how the law itself produces what I call the colonial ever-present. So how the very ontology of the law is complicit in preserving the dispossession that racialized enslavement and dispossessive colonization were focused on or produced themselves. And so I call law the keeper of colonial time in that sense. And when I say law is the keeper of colonial time, not just that it keeps the time as it marks the time, but it keeps the colonial time, the dispossession, which is sort of constitutive of that relationship between the colonizer and the colonized. It keeps that relationship almost permanent, even though it is evolving. I have also examined this particular relationship within an article which I have on the screen there called Black African Science Fiction and the Quest for Racial Justice Through Legal Knowledge. In that I argue that we need to sometimes look beyond the law to be able to deconstruct that relationship and that ontology of law as the keeper of colonial time. So when I say that law is the keeper of colonial time, we need to think about the history and the origins, or the relationship between the law and the present order of the world. The very study, the very function of law, as especially in the context of us studying law, um, is related or is concerned with the study of the human subject and that human subject's relation to society. But the very construction of the human subject has always had unequal origins, uh, and the way in which sort of Anna Greer describes it is that the very foundations of what you can call Euromodern law uh, is sort of constituted around a particular vision of a human being, the rational man. Duzenas sort of echoes the same point and describes the closest sort of laws human as the white property owning man. And then from that conceptualization, we then think about the history of the world and how the colonial ordering of the world has developed along these lines and results in hierarchies and what Boaventura de Sousa Santos calls the abyssal line or sacrifice zone. So the very production of this present order of the world is related to the constitution of laws human or the human being in these particular hierarchies. And this is important for our study, our sort of our work within the law, because for most of not just what we teach but also what we research, there's an absence of engagement with colonial law and how the ontology of the law that we presently have is very much related with the use of law with to govern or regulate or produce these colonial relationships and govern these colonial territories. So we can describe colonial law as law that is enacted to govern the population of overseas territories, but also includes the law from the metropole that granted the authority for that. So colonial laws and laws of enslavement, and I don't make that much distinction temporally, chronologically, between periods of dispossessive colonization and racialized enslavement, because, for example, in the Americas, land needed to be colonized before racialized enslavement was enacted. So there's a sort of an accumulation or a conflation between those two there. And in other colonized territories like in Africa and Asia, while colonization happened, you would say that happened first. It was also, so the administration of territory used similar logics of enforced on free labor to sort of create infrastructure like the railways, like the roads, colonial buildings and such like. So when I talk about the period of the colonial, I'm talking about racialized enslavement as well as what we considered colonization, as opposed to racialized enslavement. There's in actual fact, those two things happen almost sort of simultaneously or coterminously. So colonial laws are used, and laws for enslavement, they follow lines of pre-existing order. Essentially, the law is often brought in to regulate what's already happening, what the powerful are already doing. So the dispossession of land, the enslavement of African peoples. But those colonial laws don't stay in those territories. The logics behind them often come back to the metropole through policing, property laws, the sort of land title and labor laws. So think about the way in which we talk about law, the origins of rights, the origins of land. We often sort of, in many cases, especially in our teaching, we jump over these periods. So there's a massive absence in our ways of thinking. And to think about that colonial law and how it operates in actuality, you could say it was the formal mechanism for the oppression and the control of indigenous peoples and colonized peoples and racialized peoples. And those laws affected or were very much concerned with the minutiae of these people's lives. and established a very strict ontology distinction between who the governed and those who were doing the governing. But one must also understand and sort of accept and acknowledge that within that, the law still retains and continues sort of retained and continues to retain discourse and resistance and its emphasis on human rights. So the law is often sort of the means of oppression and also the source of sort of deliverance or salvation from that oppression. So there's that always mixed nature to how the history of law has been produced. And so a few examples of how, in practice, the law develops in this way. So, for example, the laws around, granting a royal charter to go and kidnap Africans in Africa and then sort of transport them to the Americas for slavery. A particular doctrine, so the doctrine of partis sequitur ventrum, which was used, so was passed in mostly, so it was passed in Virginia and then extended or expanded throughout the Americas in reaction to Elizabeth Key's case. So Elizabeth Key was an enslaved woman who won her freedom in 1655, and the argument she made, because she was born of a racialized white father, was that she inherited her father's status. Thereafter, the doctrine of partis sequitur ventrum was passed, which means that that which is born follows the womb, which means that any enslaved woman, irrespective of who the child was, who the father of the child was, would give birth, or would the status of the child of any enslaved woman would be that of enslavement. So essentially what happened when this doctrine was sort of instituted was that it firstly sanctioned the rape and sexual violence against enslaved African women, mainly because the people who were holding them in slavery had no fear that the children they would give birth to would become free. So and also then became this rape and sexual violence against enslaved African women became a means by which the human was entrenched as a commodity form and also a form of commodity generation. Another sort of example around this specific ontology is the case of Gilbert and Gregson. So this is the case of a ship called the Zong, which was carrying kidnapped Africans around 1781 from the coast of Ghana in West Africa to the Americas. Ship got lost, and the crew felt that they would run out of food and water, and that the cargo that they were carrying of kidnapped Africans would die, and therefore they would not be able to realize the profit on their investment. So they decided, because they had paid insurance on the cargo, to throw 130 of these African captives overboard and claim on insurance. The argument they made was on the doctrine of necessity. At the trial court, the court agreed with them and said, well, yes, this seems to be a necessity. You can claim £30 per person. On appeal, new evidence was provided, and the court doubted the concept of necessity. However, even though they, confessed to the throwing of 130 African captives overboard, the court at no point in time really strongly considered the possibility that the crew would be tried for murder, or even manslaughter. And famous or infamous quotation from the trial court, the judge says that the case of slaves is the same as if horses were thrown overboard. And you think about how, going back to the previous slide, where saying the entrenchment of the human as a commodity form and a form of commodity generation, and how we think about human value, and to think about in the present who we are still content to abandon to the waters. You think about, migrants crossing and the crisis, and also climate emergency and islands disappearing, and who we still seem to be content to abandon to the waters because we have reduced human value to, commodity form and a form of commodity generation. And also the concept of terra nullius illustrates this relationship between body, space, and time, and law's entanglement with that. So I've got two cases which sort of illustrate the concept uh, of that entanglement. So we have Wiparata and Bishop of Wellington, where the court held in 1877 that the treaty signed by the indigenous people and the colonizers was a simple nullity because it had been signed by primitive barbarians, and therefore the land could be taken from them because they didn't have any sort of recognizable legal doctrines or legal apparatus for owning land. This is replicated, this argument is replicated by Justice Sumner in 1919 in Re Southern Rhodesia, where he says some tribes are so low in the scale of social organization that their usages and conceptions of rights and duties are not to be reconciled with the institutions or the legal ideas of civilized societies. And what I, really want us to think about in through these examples is how these concepts or what these bring into the present. So the dispossession is made permanent by law. So we may frown at the dispossession and say, well, it's something that happened in the past, but how do we react to that in the present? How does that, what realities or modalities of life are brought in the present, and how is law sort of entangled in that reproducing and bringing into the present? So to think about through these particular examples, there are only a few, there are many more we could think about, and to think about and to consider in essence, how do we describe colonialism as distinguished from colonization? So you can define or you can understand colonization as the actual physical occupation of territory, of a specified territory, but coloniality, which is the word Anibal Quijano and many of the Latin American critical school uses, I would prefer colonialism. But according to Quijano, coloniality is still the most general form of domination in the world today. So once the whole sort of praxis of colonizing territory in that spatial, immediate administrative way has been destroyed, the coloniality of power sort of still remains, and it relies on the social category of race as the key element of social classification. And so when we talk about decolonization, we need to think in this broader ontological sense of the very order of the world. And we can relate this to, or to add on to this, this quote by Nelson Maldonado Torres, who says that coloniality or colonialism precedes and survives colonization, the physical occupation of territory. It's maintained alive in books, in the criteria for academic performance, in cultural patterns, in common sense, in the self-image of peoples, in aspirations of self, and so many aspects of our modern experience. In a way, as modern subjects, we breathe coloniality all the time and every day. And essentially what these scholars are saying is that racial, political, and economic domination still exist as produced by this colonial project. There has been no major rupture in the orders of power since 1492. So these are the voyages, or this date marks the voyages of discovery across the Americas and the New World, and other discoveries like the Cape of Good Hope and such like. And then we need to think about what is the relationship of Euromodern law to this or with this, or to put it differently, can we say or can we ask if Euromodern law is the heir that colonialism needs to survive, or as I put it, the keeper of colonial time, the tool to reproduce the colonial ever present? So if that's the very sort of reproduction of colonialism, what is decolonization? Like I said, we can trace it to 1492, I would say very roughly, and define it also quite roughly as an immediate, continuing, and stubborn refusal of the colonial conditions of domination, dispossession, and dehumanization wrought by or brought by the colonial project. And therefore, within UK higher education, within education at all, we must understand that decolonization is a political project instituted by people in the global south, racialized people, indigenous people, and colonized people to repudiate that colonial project. So we must avoid, as I have mentioned before, the desire to refine or restrict decolonization to, for example, adding a few topics or lists or authors to reading lists, and sort of changing names in assessment from Anna to Ali. We need to think more sort of structurally and ontologically about what law is, what it does, how it functions, but also think about history when we look to the past as a means to uncover the things that we haven't considered, that we don't usually consider as a means to understanding where we are in the present for the purposes of ensuring that we have flourishing futures, or that we have any future at all, as climate emergencies suggest, so putting into question. But to also understand that when we talk about decolonization as a tool, it's actually many things. And I mentioned this earlier, they're context dependent strategies to repudiate the colonial ever present that's sort of made manifest in different areas of the world, depending on the context in which and the way in which colonialism / colonization works, where those who are sort of arguing for decolonization, where they are working. And therefore, we must understand that decolonization, most of what we consider to be decolonization, has happened, will happen beyond the university. And therefore, it would be impossible and dishonest for us to want to take charge of that conversation within higher education. So a few conclusions, and then I'll read a short extract. The relationship between law, colonialism, and time suggests to us that through the eyes of Euromodernity, what the law doesn't know or cannot know didn't happen, and therefore there are many gaps in our understanding. Adjudication or legal practice is often reluctant to concern itself with a far past and the very far into the future. So we've got, statutes of limitations. How far back does the law want to go? And also the question of imminence. If something is a danger or harm that's far into the future, is the law concerned with it? Euromodernity and Euromodern law seeks to fragment and hold these temporal flows of time behind these accumulated legal barriers. And yet, Ta-Nehisi Coates argues that one of the main outcomes of being racialized Black in the world is the inescapable robbery of time. So time, unjust incarceration, early mortality, as Ruth Wilson Gilmore defines racism as proximity to premature death. But the law places, through these sort of the way in which it holds back these temporal flows, places strict limits on when this sort of robbery, this permanent deprivation would be an affront to itself. And so Baldwin argues or urges us to think beyond those fragmentations of time. So he says that, for example, instead of speaking about the civil rights movement, which is temporarily restricted, let us pretend that he is a witness to and a survivor of the latest slave rebellion, because, as he says, we're still governed by the slave code. So essentially he's saying, if the logics don't change, why do we change how we describe and understand these movements in time? And this brings me to the short extract I want to read from. This is at the end of chapter 5, after I've gone through all these conversations, which I've tried to summarize in this presentation. So how do we teach and research law in a world of collapsing, ever-present colonial time? If law doesn't have the language to read testamentary life, dynamic space, and accumulated time, we may need to look beyond the language of the law. Acknowledging the absences within the law, not just what it does not cover, but what is not currently structured to do, plays a vital role in effectively transmitting critical legal knowledge. Claudia Rankine's work, for example, compares the ways in which racialized peoples experience US state power in the aftermath of Hurricane Katrina with the experience of being thrown to the waters out of a slave ship like Zong. Still in the difficulty, standing where the deep waters of everything backed up, climbing over bodies, we are drowning here, still in the difficulty, Rankine writes. In drawing a shared temporality between Katrina and Zong, Rankine's words call on us to imagine that all time was collapsed into a single moment. What if slave ships were sailing right now? What if disposable bodies are being lost to the waters now? What if colonial land was being accumulated now? What if labor extraction was still racialized? What if indigenous land was still being taken and the bodies of the indigenous were still being forgotten in the ground now? So imagination becomes reality. We are still in the difficulty. A similar shared temporality can also be drawn between the breathlessness marked by slow violence that enabled the Grenfell fire, racialized disparity in police brutality across the world, vulnerability to COVID-19, including the vaccine apartheid, and the burning of indigenous lands and forests. We cannot breathe. We are still in the difficulty. Water and fire. We cannot breathe. Actual time is never fractured. Temporality is an unbroken continuum of connected memory across time, across space. We are still in the difficulty. To think otherwise is to ignore the fact that Euromodern legal knowledge destroys in itself the capacity within itself to inaugurate the most important part of inquiry, the possible futures that may come to pass for the earth and for humanity. If we fail to address this, we remain still and forever in the waters and fires of difficulty. We cannot breathe. The challenge of legal knowledge is to make all times and temporalities legible. Thus, as academics, we could commit to theorizing through the break to avoid repeating the ongoing violence in our present times. We could take up tools that imagine bodies and space-times beyond this colonial ever-present. This means to live now, to teach now, to research now, as if the future we wish for already exists, learning from a future we have not yet reached. Therefore, I end with the words of Latour, and with hope for escaping Euromodernity's inescapable robbery of time. Modernization has never occurred. There is no tide long in rising that would be flowing again today. There has never been such a tide. We can go on to other things, that is, return to the multiple entities that have always passed a different way. And I agree with Latour, surely we can go on to other things. Indeed, to survive, we must go on to other things. And I'll stop there.